European new proposal on the production and preservation order. I was at the beginning thinking on going and exhaustively on the provisions, but then, as my colleagues have said, they change it quite often. So that kind of, getting between my work and as researcher and trying to describe which were the main features and so on, keep pace of and keep track of the changes. So, and as a matter of fact, a lot of things have been already mentioned today about these characteristics. So my purpose today is much more humble, at least for the beginning. If I have time later on, I will move on to some details that might be left a little bit for further discussion. So,
if you went down instead of along.
Ooh, yeah. Oh. Wait, now here. Okay, so my question is this one: as why do we need the regulation? And it's a very basic question that I think that it's often overlooked. Today we've been discussing a lot on how we need more data, we need to access more quickly and so on. But I think that we often overlook the reason why we need that, and how we justify the need for new instruments, new measures. And this is precisely what I'm going to talk about in my time. So in order to do so, I will present you with the section of this book here, which is the impact assessment that supports the proposal that was published on 17th of April of 2018. It's a huge book of 280 pages, which I read and tried to understand. And in there, the Commission explains, or tried to explain, why are we or were we in need of a new instrument, or why authorities are in need of new instruments. So they reach the conclusions that, or they start by saying that crime cannot be effectively investigated and prosecuted in the EU because of challenges in cross-border access to electronic evidence. And the reasons, or which are these challenges, is, as it has been mentioned, that e-evidence is often stored in service providers who have their data centers in other countries from that one investigating and requiring access to data, in particular mainly on the US. Therefore, the second challenge is the shortcomings on the current channels to access electronic evidence, and the volatile nature of electronic evidence, which has been mentioned this morning, but I think in a different sense. This time what the Commission refers to is the volatile nature in relation to the principles of minimization and data retention regimes existent. So basically that the principles abiding EU data protection law prevent authorities from accessing data because the service providers are obliged by law to not store or process data beyond what is strictly necessary and so on. So these are the existing channels. They have also been discussed today: mutual legal assistance treaties, international agreements, bilateral agreements between member states requiring that streamlined the procedures, how states require assistance to another one, and the European Union, and this has shifted from assistance to recognition, and well, apparently they're too slow, or we've been discussing today that they're slow, and they represent the disproportionate expense of resources from member states. And the second, and this has, as a result of this, the Commission represents that authorities are increasingly relying more and more on direct cooperation, seeking direct cooperation with service providers. This has two possible options or variables. One is through judicial cooperation, so a judicial authority issues an order and tries to enforce extraterritorially the domestic jurisdiction or wherever the service provider has their data centers, or more informally, just sending an email or communicating with these service providers and asking them to produce data or preserve it. This is unreliable, depends on the service provider's policies, and at the end lacks transparency. Finally, the third option is to directly access this data without going through any intermediary, which is also known as legal hacking, which leads to legal fragmentation, and yes, it's not optimal. So which are the problem drivers? Again, it's a bit repetitive. It takes too long to access evidence across borders under judicial cooperation procedures, rendering investigations and prosecutions less effective. Then these inefficiencies between public and private hamper effective investigations and prosecutions, and the shortcomings of defining the jurisdiction, again, hinder effective cross-border investigations and prosecutions. That's the problem drivers. So the proposal, it's quite intuitive. Which are the objectives? To reduce the delays, ensure cross-border access wherever now it's not possible to access, improve legal certainty, protect fundamental rights, transparency, and accountability. That's what they say. And the general objective is to ensure effective investigation and prosecution of crimes in the European Union by improving cross-border access to electronic evidence through enhanced judicial cooperation in criminal matters and approximation of rules and procedures. So, and here it's where I'm going to start talking about numbers. The dimension of the problem, how big is this problem nowadays? How I'm not gonna suggest that this is not a problem that authorities are facing. I think I don't have any reason why not to believe so. I'm just going to point it out how the Commission reaches the conclusion and how it justifies why we need what they are presenting to. So they describe this dimension of the problem of cross-border access to electronic evidence by providing an answer to these three questions, which is the percentage of investigations including a request to cross-border access to electronic evidence, the percentage of requests to service providers that are fulfilled, and the percentage of crimes involving cross-border access to evidence that cannot be effectively investigated or prosecuted. And the sources of the regulation, the sources of this information are a survey addressed to public authorities in member states and the transparency reports from the service providers, 5 service providers, which is Facebook, Google, Microsoft, Twitter, and Apple, who, by the way, receive 90% of all cross-border requests of electronic evidence. So this is the first table or graphic. This is all from the book, and you can check it out later. It's I put the source, but not the page, but it's the first 20 pages. So percentage of investigations, including, and here, yes, I'm gonna check my notes. Percentage of investigations, including requests to cross-border access to electronic evidence. The Commission estimates that electronic evidence, and this is using, well, yeah, we'll mention that later. Estimates that e-evidence in any form is relevant in around 85% of total criminal investigations. In here, we're referring to electronic evidence in general. The proposal refers to another concept of electronic evidence that, as I will explain later, is electronic evidence that is processed or stored by or on behalf of service providers. So it's just that specific notion of electronic evidence, which I will go afterwards. From these 85% of investigations that required electronic evidence, 65, 2/3, involve a request to service providers for data. And doing a median of these two figures, they reach the conclusions that 55 of total investigations include a request to cross-border access to electronic evidence. So the thing is, where do these numbers come from? And the answer is that we don't know. We don't know because for these particular questions, the numbers come out a little bit out of the blue, and I encourage you to go and check it afterwards. The report only refers to these figures by reference to an evolution of the number of member state requests to the main service providers, which is this graphic out there. And I quote here, they use this graphic to have an idea of the number of requests reflecting such percentages. So it's not so obvious. It should be noted, however, that the reports, the transparency reports from the service providers, do not distinguish the type of requests. As service providers do not separate between requests of judicial cooperation and requests of voluntary or informal cooperation. Therefore, there is no way to know which proportion of the requests considered were formally issued during a criminal investigation, or on the contrary, could relate to fishing expeditions for data. That's the second, here. The second one, percentage of requests to service providers that are fulfilled. Now, this table comes from the survey to public authorities. I will go a bit more into detail about what this survey is, or the methodology and the content of that data. But fundamentally, this table shows the result of the survey, blah, blah, blah. It breaks down the percentage of requests and its fulfillment rates based on the type of data. So we have non-content data, content data, and non-content data, then it's break it down in subscriber and metadata. From it, it follows that judicial requests, the requests under judicial cooperation within the EU appear to be fulfilled 75% out of 100 times when it comes to subscriber data, and 60 out of 100 when it refers to metadata. Positive responses to requests of direct cooperation for subscriber data and metadata are, on the other hand, slightly lower, reaching 55% and 45% respectively. And finally, requests for content data are answered under judicial cooperation 55 times, or 55% of the time. The number dropped below 50% in all categories when the requests are addressed to non-EU service providers. And the Commission from this table extracts three conclusions: that subscriber data is easier to obtain than content data, that requests within the European Union are fulfilled more easily than in non-EU countries, and that less than half of all the requests to service providers are fulfilled. So only 40%, 45% of requests for data to service providers are fulfilled according to the Commission. And here a question, another very basic question I put: why are the 55% of the requests left unfulfilled? And according to the service providers' transparency reports and the target survey, the reasons are these ones: possibility that a request is sent to a wrong provider, that it is drafted in an excessively broad or unclear manner, it fails to specify an existing account or sought information, it does not have a valid legal basis, or the data sought no longer exists. So here, what I would like to point out, and this goes a bit in relation to what has been mentioned before on the capacities and the understanding of authorities of the instruments they have, and the notions of electronic evidence and what they mean and how, what they imply. What we see is that the 5 reasons, only one relates actually to the notions of electronic evidence. The other 4 are simply or basically referred to the literacy of our authorities in making use of the instruments they have in their disposition. So the Commission indeed recognizes this, and as a matter of fact, as one of the non-legislative actions that they foresee in the impact assessment is precisely to invest in capacitation of the practitioners and authorities. But apparently that's not enough without a new instrument being put forward. So the third one, percentage of crimes involving cross-border access to electronic evidence that are negatively affected or cannot be pursued. And the title, I think that it's already misleading, because what does it mean? I mean, I think it's misleading to put together investigations that are negatively affected and investigations that cannot be pursued. There is two different consequences with, well, I mean, the level of intensity is it's quite, yeah, it's sufficient enough to separate them. But this is precisely what I'm pointing out here. It's the lack of granularity on the data provided by the Commission that, yeah, that prevents us from having a better assessment of the situation. So going back to the table, yeah, you see here the causes that. Within the European Union, we have separated within the European Union, non-EU countries, judicial and direct requests. The conclusions that the Commission reaches is that almost 2/3 of crimes involving cross-border access to electronic evidence cannot be effectively investigated or prosecuted, and that direct cooperations seems, and this is a quote there from them, the direct cooperation seems to be a more efficient channel than judicial cooperation, in particular with service providers based in non-EU countries. Let me see here. So yes, I will rest. Yeah, I have two comments on this regard. The assessment gives little insight on what is to be understood as a negative impact for criminal investigation. And secondly, it sets an implicit cause-effect relation between the lack of immediate access to data and a prejudice on an investigation. While that might be true in a specific situations when the data is indeed in risk of being erased or removed, it might be overreaching to consider that timely access to data is equally relevant for all types of offenses and to assume that it has an equal impact in all cases. The same reasoning could be raised with regards to the impossibility of accessing data at all. Because the impact assessment does not clarify the type of offenses and motivating requests for production of preservation orders, there is no way to provide a reasoned assessment based on necessity criteria. In that sense, the Commission seems to extrapolate the investigatory needs of specific crimes such as cybercrime, terrorism, child pornography, or organized crime to the investigation of crime in general. Indeed, while in some occasions that might be the only lead for the investigation of crimes, it is not so clear that the sole existence of the digital trace should justify by itself a generalized dependence on investigations on data. That's my opinion. So the sources. I mentioned before, the first source is the transparency reports of Apple, Facebook, Google, Twitter, and Microsoft. This only relates to direct cooperation. The second source is the target survey number 2 annex, which is in annex, in the second annex, and also in annex 11. So you have annex 2 that refers you to annex 11 in a not so clear and research-friendly way. So here, the purpose of this survey was to collect quantitative and qualitative information on the size of the problem concerning cross-border access to electronic evidence through both judicial cooperation channels and direct cooperation between public and authorities. So what I'm interested is in this, and I know that we have data analysts here and might give us a hint on this issue. There are 76 responses of this survey. 68 of them were from law enforcement authorities, 5 from judicial authorities and from public administration officials. And I'm not saying, I'm not implying anything from law enforcement authorities. I think that their opinion is quite course, it's super useful and it must be taken into consideration, but perhaps it's not so clear. It does not provide a complete picture of how things are, considering that there are other authorities involved in this process. So I end up questioning this and raising this to you. Is access to electronic evidence almost always needed? Are available mechanisms fit for cross-border access to data? Does access to data negatively affect all criminal investigations equally? And finally, I question whether the European Investigation Order, and I raised this point before this morning, has been prematurely assessed, and in this regard, after this meeting and during the workshops, I think that it's an often feeling, it's a repeated feeling, that authorities are not so sure how these instruments work yet, and it's normal because it's pretty recent. It has only been transposed into the law of the member states, of those who implemented it in July 2018, and so it's quite it's not so strange that the best practices and the experience and how to use this instrument is not yet developed. And besides this, the Commission in the impact assessment also foresees the implementation of technological solutions in order to boost the efficiency and capacities of this instrument, and they acknowledge the possibility, the potential effects, beneficial effects that this might have in the instrument as a whole. So perhaps it would be wise, and I'm of the opinion that perhaps it would be wise that before moving forward to new, to the unknown and presenting alternatives to it, which might be considered at some point, but first it would be wise to assess whether we can improve what we have right now. And just a comment on this, because it took my attention. In the qualitative assessment that the Commission does precisely on the European Investigation Order, they dismiss on the possibility to precisely carry on only with the order because of its limitations in terms of jurisdictional scope, and secondly, due to the lack of incentives for all member states to invest the necessary resources to ensure its efficiency. So, given, and here I mentioned, given the secondary role of enforcing authorities, perhaps it should also be questioned which is going to be the incentives of service providers to prevent from abuse of the production orders in the future. It's just a thought that I raised. And here, I don't know how much time I have left.
Well, we're supposed to finish at 5, so we have.
I don't have 30 minutes more to talk anyway.
No, we have 20 minutes for a round of questions.
Okay. So then let me see. The investigatory measures, we have discussed this. The following slides are just an explanation of the main elements of the proposal. I have some comments that I would like to make. I'm not going to go through. Well, it's binding decisions. We have already discussed this. Living document changes, September, October, December, and the negotiations now are going to go to the Parliament, where they have to decide which position they're going to take on this document. And so, what we have right now, it's probably not going to look very much to what we're going to end up with at the end. So here I made some pictures, and just to illustrate how is the procedure, how does it look like visually and with colors. So the issuing authority sends a certificate which is not the order, to the legal representative. The legal representative has 10 days, 6 hours to produce preserved data. It can object to comply, 5 days to notify preserved data in any case. And then the authority that issued the certificate might then request for enforcement or not. And then we go to the second one. So in this one, the request for then here it's the first moment where the enforcing authority appears. It's at this point of the process. So we see here normally, and that's what we mean by the lack of judicial scrutiny or a secondary of a secondary judicial authority. It's because this procedure just contemplates the intervention of the authority in the enforcing state in the case that the service providers does not comply in the first stance. So here, yes. Well, that's all. I just wanted to show you how it looked like, the options and so on. And this is useful for me to go to this point, which I think that it's interesting, because the Commission presents this proposal as a new dimension for mutual recognition. They say that it enhances the recognitions of member state judicial decisions, and accordingly, the proposal is grounded upon Article 82.1 of the Treaty of Functioning of the European Union, and treats it as a judicial cooperation instrument. So here, in practice, however, as I tried to show you before, the initiative represents a direct cooperation procedure, as it allows law enforcement and judicial authorities to directly compel service providers to produce or preserve data, without necessarily involving the judicial counterpart from the member states where such service providers is established or represented. In other words, the proposed regulation contemplates the mutual recognition of the issuing state's decisions without an actual recognition from the judicial authority where the data is being requested. As explicitly, and this is explicitly expressed by the Commission, the EPO regulation is a direct cooperation framework between service providers in control of evidentiary data and the authorities seeking it. Consequently, it should be questioned whether the proposal is still consistent with the defining elements of judicial cooperation. Again, given the fact that the interaction under the initiative does not strictly involve judicial authorities but service providers, the interpretation and application of mutual recognition principle in the context of judicial cooperation does not seem adequate to me and to many other organizations, including the European Data Protection Board, the former Working Party 29. So I continue. The Commission's new dimension of mutual recognition might indeed facilitate the free flow of judicial decisions in the area of freedom, security, and justice for evidence gathering, but at the expense of replacing cooperation with blind trust. The EPO regulation processes a scenario by default of production by default and a strict adherence to the judicial decision of the issuing state, precisely in a moment when mutual trust in the European Union is increasingly called into question. Whilst the principle of mutual recognition presumes beforehand a correct functioning of the different national legal systems, it does so without neglecting the possibility to reject such presumption. Through the marginalization of the executing authority, the regulation might de facto cripple member states' capacity to doubt, and as a result, desnaturalizes the significance of the responsible trust over the member states' compliance with the European Union legislation. So that is common. And here, the scopes of the regulation. Can I continue? You think? So
we still have 2 or 3 more minutes, if you're fine.
3 or 4 minutes? Yeah. Okay, then I'll just focus on, because these things are the three main elements around which the proposal is orbiting, and they define which authority is gonna be able to request what, and yeah, and in which with regard to which offenses. So yeah, I'm gonna go only just to mention the service providers personnel so very quickly. So we cover electronic communication services, information society services, internet domain name and IP numbering services. This is important because, as I said before, this defines the notion of electronic evidence that we are discussing. The legal representative, as it has already been mentioned, service providers have the obligation under this regulation to nominate a legal representative. If they do not do it, or then the authority is going to refer to the establishment, and if they don't have an establishment, they're going to be sanctioned. Territorial scope, and this is also an important one. The regulation represents a new ground for jurisdiction. A certificate on a European order, preservation order, can be issued for with regard to regardless of where the service providers are established. So it's not relevant anymore, this territorial aspect of the provider, but their substantial connection with the European Union. And what do we mean by substantial connection? Article 2.5 of the regulation establishes three main principles: the existence of an establishment in one or more member states, the significant number of users, and that they're targeting activities to one or more member states. There's a typo there. And here I'm just the material scope, the concept of electronic evidence. Okay, we went through it, and then this is the different definitions of types of categories of data that are comprised within the notion of electronic evidence, which is mentioned by the European Data Protection Board. They're all referred to personal data, and that's why precisely this is not or this is considered not to be electronic evidence, but a proposal, request for access to data, to personal data. And I'm just going to refer to what the EDPB expressed in their opinion of the 26th of September. There is no clear difference between the categories, in particular with those relating to access data and subscriber data. What the Commission, and this is in my view, what the Commission is doing here is that they're with the categorization on content and non-content data, they're omitting the notions of traffic data. So and this allows them to create this new instrument, this new category of access data, and put it in the same level of subscriber data, which, as we will see, has a lower threshold of requirements to be requested by the authorities. Yeah, according to the EDPB, this is not sufficiently substantiated, and this has been raised several times. The problem with this interpretation of that puts the Commission is precisely that traffic data is, according to the Court of Justice of the European Union, is no less sensitive than content data, and therefore these arguments or this positioning, it seems to be contrary to the case law. In line with what Gemma was saying before, and the profiling character of traffic data, yeah, there's a lot of information, and there's a lot of processing and outcomes that can be reached through aggregation of traffic data. Why it's important, the separation. When you want to finish,
you can complete it, finish it.
Okay. So why it's relevant? Because depending on whether it's subscriber access data or whether this is transactional and content data, you will have issuing authorities, certain authorities will be able or not to issue the orders. So, for instance, for subscriber and access data, because of they are considered to be less intrusive, they are allowed to be issued by prosecutors without a court order, while this is not the case for transactional and content data. And Thijs was mentioning before that even the document says this, and in Spain that would be translated differently in practice, right? That the
Well, I'm not sure, but if for national cases we cannot do it, we have to have a court order. I think in this case we will need it too.
The thing is that what surprises me is that they are so specific from judges, court investigation judges, and prosecutors. My impression is that they are precisely trying to allow prosecution from being able of accessing subscriber data and access data without a court order, which is again conflicts with the case law of the Court of Justice. Yeah, and here I don't know if there's anything.
We can now open the floor for some specific questions in the remaining time.
Okay.
Because we wanted to have
Thanks.
a lively discussion with the. Thank you, Sergi. We want to. The idea of this last part of the session was to have a lively discussion with the participants, and I am pretty sure there might be some questions concerning the last part of his presentation or Gemma's presentation. Please go ahead.
Okay, we can start. Thank you for the presentation.
Thank you.
It was very nice. Just one very speedy question that relates to exactly that concept of access data.
Yeah.
Broadly speaking, the access data that is indeed predicted must be interpreted not accessing the transactional data associated with that, because that's already in the possession of the law enforcement or whoever is the judicial authority that handles the case, but only the subscriber information associated with that transactional data, which is a one-shot only, okay? So basically speaking, to give you an example, if you have a plaintiff that gives you an email which is in itself evidence or even a crime, okay? Never mind which one, just for the sake of argument. In the technical metadata of that legally obtained email, you already have the transactional data. You have a communication between two IP and two ports, okay? And a specific timestamp and all the information associated with that communication. What you do not have is the identification of the original recipient, which is the sender. And that is exactly what access data means, okay? It can also be meant to be the data associated with the subscriber, with the subscribing of the service by the person which is already identified, okay? Both ways. I believe this caused a great discussion, and supposedly there was a proposal on the last meeting to include that specific point of access data within the scope of the subscriber data, precisely to avoid this problem. You can confirm that, okay? Just to see that this is, broadly speaking, what the Commission had in mind, I suppose, in the beginning, okay? Then, in the discussion, a lot of other contextual information was put in. Nevertheless, this is not really an access to a data that you can profile. It's one shot only, okay? You cannot make great profile with access data.
Well,
I can tell you.
Can I interrupt you?
Sure, sure.
Because
Please
if
go
you
ahead.
go to the description of what access data has
I know.
involved in, you see there such as date and time of use, or the login
Log in or log off of the
from
service. Precisely.
Precise. So if you
It was broadened, but the original intention was
Okay.
a little bit slimmer.
But as it is right now, this can give you a quite detailed profile information of what this
Yes.
user
Yes.
does of
The only limitation here is one shot. It's what's not there. Because if I access the service to create my account, okay, that's a legitimate data, one shot. But I cannot create a profile of all the single accesses that I have. That's transactional data. In fact, so the distinction must be made on this level, and probably within the discussion, because this is not exactly the term that was present in the beginning of the discussion, the changes that are being made are not going in the right way, and that I can concur and agree with you. Nevertheless, in order for this to work, there is another question. We are talking about data retention, okay? The consequences of the Watson and Tully 2 judgments, okay, which are not properly interpreted. Has been a lot of confusion, and there are a lot of work groups sponsored by the European Commission to deal with the problem. But nevertheless, I would like to ask you a concrete question about this, because for this to work, and if it's going to be implemented, you will need a principle in base, okay? What do you think should be the scope and the duration of the obligation of data retention in the future alteration of the directive that will impose this on OSPs, okay? Your view on this?
My view? I mean, I don't know if I'm going to answer, I'm going to reply or satisfactorily to your question, but what I would say is that the regulation foresees a possibility to preserve data, and in a way that data retention is key. And actually, that's one of the critics that the European Data Protection Board raises, that the regulation provides for authorities to request the preservation without actually setting the limits of it. So in a way, this might be an undercover Tilly to circumvent mechanism.
But the scope is important, because on Tally 2, the court really got to the point where they admitted a positive, and in some cases negative, discrimination for the early one-shot preservation of evidence if you have a general suspicion over a certain group or even a certain locality. They even refer to the term geographical, which is, I believe, a problem, because it impedes a series of rights, and it gets to a prejudgment that has absolutely no basis to be done. It's discriminatory, okay? So, your views on this?
Wow. I think I have disconnected, to be honest. during the last 10 seconds of your, I kind of switched off.
It's technical, but it's important, isn't it? Because you're right, because it is a fundamental importance about what you mean by that data, and
what are we talking about?
And the scope within which the provisions could be used that are outside of what was planned, or what they thought they were to be used for, and they obviously shouldn't be able to be used to circumvent in that way. So they need to consider how they're going to. I'm not quite sure how you would go about changing the proposals in order to prevent that.
It's difficult to consider a single and specific rule, but certain criteria must be attended. So the question is really this: what is your criteria for this? Because this is the main issue. If we are obtaining data, we must be sure which data are we obtaining.
Yes, and in that respect, I don't know if you have checked the European Data Protection opinion on this, because they mention the possibility to introduce the notion of electronic communications data from the e-privacy regulation proposal. And so I don't know if that might somewhat...
It's a way. Do you agree with that way, for instance? Or do you think it's too broad a definition?
I wouldn't dare to broad out my opinion as something that to respond to your question right now, but as part of my research is something that I'm interested in looking forward. So yes.
Okay, satisfied.
Thank you.
I don't know, Carlos, if it's a little bit in the line of your thought, but one of the discussions we have now in Maastricht is about data integrity. And not the data sets per se, or the information that you can access. It's important, but it's a little bit, we need to think the second line of thought. So who will validate the data sets? Because that, in the end of the day, one of the big problems that the courts will face. Not only who access, for instance, I remember that in Dublin we had two corporations on forensics that many authorities can even access as a service. So in a sense, what could be the level or the entity created to have the last word on the data integrity? Because it's not only about collection of data. It's about data integrity.
Exchange. Yeah, maybe here my colleagues from the technical side will have a better insight on this. I'm familiar with the project Evidence, and they've been developing the e-codex tool, and I think that that's going to probably, or that's the thought that through technical solutions this question is going to be answered. But indeed, I don't have the knowledge to reply to your question at this point.
So is there any other question you would like to address the panel with? Any other question concerning the presentations we have today before we close this session? Because otherwise, I think